Mr. President, in March this year, you received 3 petitions pursuant to Article 146 of the Constitution 1992 for the removal of Chief Justice Gertrude Asaba Araba Sakitokon, and the public was made aware of this fact. Subsequent processes dictated by the Constitution and the decisions of our Supreme Court were gone through, culminating in the establishment of our committee under Article 146, Clause 6 of the Constitution. The nation was further duly informed, and when we commenced our work on the 15th of May 2025, the Minister of State for Government Communications was briefed and notified the public about it. There has been considerable interest in our work, shown through comments and opinions by Ghanaians and international observers as well. However, the committee restrained itself all along from reacting, even when blatant false statements were made about members of the committee and our work. To the committee, our mandate and remit is set out under Article 146, Clauses 7 and 8 of the Constitution. It's clear, and it is to inquire into the petitions in camera, hear the person against whom the petitions have been brought in her defense, by herself or by her lawyer or other aspect of her case, and then make a recommendation to you, Mr. President. As I have said above, 3 petitions were referred to us, and though all 3 petitions seek the same relief, each petition is distinct and would succeed or fail on its individual strengths or weaknesses. Mr. President, without disclosing the substance of the proceedings, and since in-camera proceedings is not the same as in secret, we can state that in respect of the first petition, we received evidence by Mr. Daniel Oforo, the first petitioner, through 13 witnesses. Similarly, the Chief Justice in her defense called 12 witnesses, including expert witnesses, as she is entitled to do under the Constitution. The Chief Justice testified personally and was cross-examined. The committee received about 10,000 pages of documentary evidence from both sides. There were 4 lawyers that represented the first petitioner, Daniel Ofori, and 4 lawyers represented the Chief Justice. Mr. President, after critical and dispassionate examination and assessment of all the evidence, including the expert evidence, against the provisions of the Constitution and the relevant laws, we have, without fear or favor, arrived at a recommendation on the first petition. The recommendation is contained in the envelope which I now give to you.
So that is exactly what happened just a few minutes ago. In fact, this is fresh on the plate, what you're just seeing right now with the chair of this 5-member committee that was charged with the responsibility under the Constitution, specifically detailing their work in the provisions of Article 146. And that's Justice Gabriel Scott Pomang presenting the report to the President for on behalf of the members of the committee. You had the likes of Daniel Yardomelovo, a former Auditor General, who is the chair of the Economic and Organized Crime Office as a YOCO board now, together with some other distinguished persons who served on this particular committee, this 5-member committee. Then as you hear, the chair of this committee detail the work of the committee, what they've done over the period that's led to this particular decision that has been communicated now to the President, and the President also communicating to the members of the general public, Ghanaians, as well, through this statement that we have just put on the screen. So that's the details of it. That's the breaking news right now. So this decision was guided by the Constitution every step of the way, is it not?
Yes, and Alpha, just to add that you also hear the chair of the committee also indicate that while they were doing their work, there were also some allegations made against them, but that they focused on their work and they got it delivered. And that's very important because when you look at some of the legal hurdles that this committee had to cross or that had to be dealt with for the committee to do its work, some of them had to do with some of the members on the committee, particularly the chair of the committee himself, had been specifically named in some of the lawsuits, and the other chief Supreme Court justice who happened to be on that particular committee. Also, there has also been an instance where the entire membership of the committee had been challenged, and that is part of the things that we're looking at. So the first legal action that came against the committee was that was brought by Vincent Ekosafwa, the old Tafu MP. For him, he thought that the part of the Constitution, especially Article 146, some interpretation be placed to indicate what the procedural line should be, because his argument essentially was that once the president received the petitions, he ought to have given copies to the Chief Justice, and that for the fact that that did not happen, it was an unlawful procedure that was adopted.
Yes.
Subsequent to that, he brought an application for injunction seeking to stop the committee from doing its work. On May 7, 2025, the Supreme Court dismissed that particular injunction application. It didn't end there. By May 21, 2025, the Chief Justice herself files a writ of summons challenging the legality of her suspension. Mind you, by this time she had been suspended, and that she also sought an injunction to halt the committee from proceeding its work. Part of the averments in this particular process was to the fact that some of the committee members had vested interest in the matter, for which they should not have been part of the committee.
Yeah.
By May 26, 2025, the CJ filed an affidavit. This was a supplementary in which she made some allegations of mental torture. She said that there was bias against her, and it was in this particular one that she made reference to the fact that the way in which the committee was going about its work, including how she was even searched before getting to the premises in itself, was problematic. However, this was not admitted in evidence because clearly the argument from the side of the Attorney General was the fact that this is supposed to be something that's supposed to be in camera per Article 146, and that was not even allowed in evidence in the first place. Fast forward, Alfred, May 28, the Supreme Court, in a unanimous decision, rejected the injunction application that was brought by the Chief Justice herself. Mind you, even before the Chief Justice had come, 3 earlier ones, including the Vincent one, had been dismissed. By June 2025, there was a press conference that was addressed by the Chief Justice herself, in which she addressed a number of issues, including reiterating allegations of bias and how the whole process had been impugned, for which she did not think that it was fair to her. Fast forward, by July 4, 2025, she filed the case at the ECOWAS court, by which time she was demanding 10 million in damages for what she says that was not a right process. The Human Rights Court heard the application. They are yet to deliver their judgment on that particular one. And this was in respect of the ECOWAS court. That was not done. She went back to the High Court, this time around, filing a judicial review, basically challenging the procedure that had been adopted by the committee, and also alleging the breach of human rights.
Absolutely. And these are cases that are still in motion, and the courts have not determined the outcome of it.
Yes, for the substantive ones, yes, but the injunction applications, those have been determined and dealt with.
Perfect. And let's stay the steam on that, and let's go on to Zoom right now. Martin Pebo is private legal practitioner, and is one that we've been engaging right from the beginning of this entire process, where 3 petitions at the start, that's what we were told at the start of it, 3 petitions were received, and it was the first petitioner, Daniel Ofori's petition, that formed the basis for this recommendation by this committee headed by Justice Gabriel Scott Palmer, whom you see right there presenting the details of this report by the committee to the president. In that brown envelope, the president received it. You have all the other members of the committee as well seated at the table with the chair, Justice Scott Palmer, who presented it. The Chief Justice, that's the Chief of Staff as well, was there. And Martin Pebo is joining us on Zoom right now as private legal practitioner. Counsel, good evening. Thank you very much for joining us. And when we started this conversation months ago, you had indicated that it would have served the now removed Chief Justice some good if she had resigned right from the beginning of this. Well, the process has gone full scale, and this is the outcome. The president has communicated a decision to have removed from office based on the recommendations of the committee and their findings on Daniel Ofori, petitioner one's petition. Counsel.
Yes, well, so like they say, the law is the law. So at this juncture, the law has taken its course, and so that will be it. We're hoping that this will bring closure to this case so that we can, go on to concentrate on other matters of improving the judiciary. Yes, I mean, my position, as I said earlier, I was hoping there would be a window for her to resign way from the beginning. But, it didn't happen. Also the Supreme Court too had held that in the Justice Utaderi case and also in the Frankie J. Chum case, that once they start the hearings, then the respondent, that's to say in this case, the Chief Justice has no right to resign. I was hoping there would be a political settlement that would have resulted in a resignation. But as I said, that was hope. But all of that didn't materialize. So once the committee is done with its work, and then that's based on the first petition alone, and once she's been removed based on the first petition alone, I mean, well, that's it. We will see whether the committee will have the appetite to go into the other two petitions. It doesn't appear it will be a good use of our time, but that's just my personal opinion. Let's see how it goes. So Article 146, well, that's been it. We're hoping also that going forward, the Constitution Review Commission, based on what we've seen in these proceedings, would strengthen the provisions to make them better in future. I think that's what I can say for now.
See, and you're saying indeed the case that the decision of this committees to have the Chief Justice removed was on the basis of the details of the first petitioner, Daniel Ofori's petition. So the other two, you'll say that, in your view, it would not serve the good of time if the committee goes into the other two?
Absolutely. Absolutely. Yes. Because right now, she's been removed. And so once she's been removed, I'm wondering what good it would do to continue the hearings. But in law, well, it's allowed, because once the cases are still before the committee can go on. It would also be within the right of the petitioners to withdraw, to say, look, okay, if Madam Torkornoo has already been removed, they want to withdraw from having their cases heard. Yes, so that maybe, because you see, I'm saying this because let's not also forget, Madam Torkornoo is fought this case every step of the way. My colleague, Wedam Puabri, has already, gone through, both of you have gone through the milestones. The, filing a case in the ECOWAS court, now the final one being the so-called group of the Bar of England and Wales, jumping in, a letter that a lot of us had issues with in terms of its authenticity, not being signed, and the language in the letter, etc. But whatever it is, there was such, traction, that at every point she sought to fight back, and the various fora, etc. she's been through have resulted in a way, in giving us bad press. We can't run away that we've suffered bad press, a reputational damage to the brand name Ghana, because you see the kind of things that the so-called Bar of England and Wales wrote in their letter, the Commonwealth Lawyers Association also wrote earlier on. You see all that language taking us to the ECOWAS court, all those things, and the allegations of bias and all that, they've hit us. They've damaged us a bit. So for me, usually, if you can avoid litigation, avoid it. It's even in the Bible. But the Bible says that, hey, if your brother, somebody is taking you to court and you can settle the case on the way, you settle it before you go and then you get thrown into jail, right? There is something like that in the Bible. So in this case, we are looking at protecting the brand name Ghana. We are quite a strong democracy in this sub-region. but globally, we are still a fragile kind of democracy. So when there are issues like this being circulated internationally, it reinforces the notion that we are still not that much capable of running our own affairs. So it's in that context that I was hoping that maybe the second and third petitions would not be gone into so that we can, have closure.
But you made the point about the Chief Justice challenging this process every step of the way. And the details as Justice Korpoaman gave today complements that point that you made, because the committee had evidence from 13 witnesses on behalf of the petitioner. The Chief Justice, well, the now removed Chief Justice, also testified and was cross-examined. She called 12 witnesses, including experts. In total, the panel said they received approximately 10,000 pages of documentary exhibits from both sides. Each side was represented by 4 lawyers. It's a very meticulous process we've seen play out up until this point, is it not?
Yes, absolutely. Yes, it's been grueling. Yes, because, to have 13 witnesses for the petitioner, 12 for respondent, 25, and you see each one of these was given evidence. So that's what we call evidence in chief, right? Through the witness statements that the witnesses filed, then cross-examination. So cross-examination of all these 25 persons. It's a lot. It's a lot. It's not a joke. That's quite a robust process, rigorous and robust. And of course, it's taking a toll. Because from dispatches that we could hear, for them to have finished this quickly, they would go in the morning and close in the evening. So it was usually a full day's work, morning to evening, right? A number of days in the week. So it's been a lot of work. Yes, that one we can't run away from it. And in natural fact, we should commend the committee and everybody involved for cooperating for this work to be done in such a time.
And we know that the Chief Justice has a dual role. I mean, as a judge or a justice of the Supreme Court, and then also the head of the judiciary. Now, she's been sacked as the Chief Justice, essentially the head of the judiciary. What happens to her role as a justice of the Supreme Court?
Okay, yes, so with this, it goes the two of them. Yes, it goes for the two of them because it's not that she misbehaved as Chief Justice separate from being a justice of this